in Regions Bank affordable housing. I'd like to reserve 5 minutes, if I could, for my rebuttal.
All right, sir. You may proceed.
Yep. Thank you, Your Honor. This case is half about Rule 24 and half about a bad fee order. So let me begin with the intervention piece and where the parties are. This limited partnership in the year 2005 borrowed substantial sums of money from the lender whose name is in the style of the case. The limited partnership is composed of Gateway Charter LP as the general partner, and my client, the limited partner, is composed of Regions Bank and RBAH. In 2014, the general partner and the limited partner got into litigation over an alleged breach of the limited partnership agreement. In 2017, the property which the limited partnership owns became the subject of a foreclosure action, and I say action advisedly, became the subject of a non-judicial foreclosure advertisement. At that time, Regions, as the limited partner, received notice of the foreclosure action and received notice of the demand. Regions, of course, and I use Regions as shorthand for the limited partner. A limited partner under the Tennessee Uniform Limited Partnership Act has limits on what it can do and what it should do. The limited partner defers to the general partner to act and represent the limited partner's interest, all of which is quite important in this case. The general partner owes the limited partner responsibilities under the limited partnership agreement, which were addressed. Now, at some point, as near as the record shows, no earlier than 2020, Regions became aware of this litigation. I would point out, however, that Regions, as a limited partner, had no right to intervene and no reason to intervene. As the record makes clear, Regions wanted the property, which was the only asset of the limited partnership, sold, whether by contract or auction, didn't matter. Regions wanted it sold. That, once the 2017 case, the instant case, became clear as where it was going, Regions had no reason to intervene. Now, things changed in late 2020 with the approval of a contract for the sale of the sole asset of the limited partnership, because the proposed contract called, an order approving that contract called for the payment of the proceeds to the general partner directly, which in our opinion was not in accordance with the limited partnership agreement and not in accordance with the law. So at that point, for the very first time, Regions had a reason to intervene.
I thought you said you didn't have a right to intervene as a limited partner.
Actually, Your Honor, let me address the rule itself, which I think talks about that. Let's look at Rule 2401. Upon timely motion, any person shall be...
I'm talking about your right as a limited partner.
No, Your Honor, the right as a limited partner is the right to rely upon the general partner's actions. The general partner has the general partner's duties. The limited partner cannot manage. Obviously, trying to manage or enter into a management decision can jeopardize a limited partnership statute under the ULPA. That's what I referred to.
Okay. Well, you made the blanket statement that you had no right as a limited partner a moment ago and had no reason to do anything other than act as a limited partner. So I'm wondering where you got that right. I understand what changed. The facts changed.
Exactly, the facts changed.
But you either have the right as a limited partner to challenge what a general partner does, or you don't.
Clearly, you have the right, and to the extent that I overspoke, the limited partner's rights are defined by the statute, by case law, and by the agreement, and by the rules in this case. And that's why I wanted to go directly to Rule 24, because intervention is not appropriate unless the movement's interest is adequately represented by existing parties. That's 2401. Until late 2020, the general partner adequately represented Regions Limited Partnership interest because the general partner was permitting or allowing to happen or encouraging, I'm not sure how you would do this, the sale of the property. And the sale of the property, again, suited the purposes of the limited partnership agreement and the limited partner. So at that point, Regions did have no reason to intervene. Regions acquired a reason to intervene when the proceeds were directed to the wrong place. Hence, in late 2020, Regions moved to intervene solely for the purpose of safeguarding those proceeds. At that point, things get interesting. There was a hearing. The chancellor gave Regions and the parties a full hearing, allowed discussion, denied, and I put that in air quotes, Regions' motion to intervene, but gave Regions essentially the relief that Regions sought, which was to safeguard the proceeds pending further actions of the court.
So is the action of the trial court in the first motion to intervene an issue for today?
I don't think so, but I believe the general partner believes that it is, because the general partner has argued right along that we should have appealed that order, and if we didn't, we lost our right to intervene, which I did not understand to be the law. Again, the resolution of the first motion suited Regions. As the court laid out, it protected Regions' interest in the proceeds. It changed the relief that was asked for by the parties because they had asked the money to go one place and the court changed, according to the court's orders, to something else. Now,
I understand your response to that, but you weren't allowed to intervene under the first motion.
Your Honor, that's why I put it in air quotes. What does it mean to intervene? If it means if intervention means the court enters an order denying intervention, then no, we weren't allowed to intervene. If, however, the court does that, but at the same time permits us over and over again to argue and participate, and in the court's own words, consider our objections in the second motion, the court has effectively granted intervention, no matter what the court does.
Well, I'm just trying to get the parameters of the appeal.
The parameters of the appeal are simply this. Ultimately, the court directed the payment of $200,000 and some odd as a closing fee when the attorney performed no services for closing. And that $250,000 came out of Regions' proceeds. That's the guts of the appeal. The guts of the appeal, quite simply, are precisely...
Let me be more precise then. The road that you're traveling to get there, are you traveling under the first motion to intervene or the second motion?
The second.
Okay. So, except for historical purposes, what's the relevance of the first motion to intervene?
I don't think it has any. I think we had an entirely new right to intervene when the second motion was filed. I think that's in accordance with the law of the state of Tennessee. We filed that motion. The motion was denied by the court. We moved to alter or amend it. The court permitted...
When the court denied that motion, Mr. Shelton, again, the court said that he...
Excuse me, Your Honor, I'm trying... Oh, I'm sorry, Your Honor.
No.
I'm sorry.
He was talking, not me.
I apologize, Your Honor.
I say I'm going to Judge Stafford sometimes.
We get confused all the time.
When the court denied your second motion to intervene, it also said that it considered your objections. Is that correct?
Yes, Your Honor, that's correct. Now, that was an oral finding, which is in the record, that did not appear in the order.
So this April, in the April 19 order, April 1921 order, this is the order regarding the attorney's fees. The court said, prior to ruling on the motion, the court also gave due consideration to the filings by non-party, Regions Bank.
Yes, sir. Yes, Your Honor.
And Regions Bank's amended objection to the Spence Law Firm's motion for attorney's fees.
Yes, Your Honor.
And then went on to say, in paragraph 11, again reiterates that, and then says, nevertheless, after denying the intervention, nevertheless, the court, as stated herein, gave due consideration to these filings.
Yes, Your Honor. That's granting an intervention. If he gives due consideration to our arguments on the merits, then in that situation, he's allowed intervention no matter what he's called it. And that's what the Lamar case basically says that we cited. Although in the Lamar case, the court simply didn't rule on intervention. In this case, the court, again, air quotes, denied it, but heard us.
I want to ask you about, I know you were getting, your time's run, but I want to ask you about this anyway. You're about to mention Rule 59, and the question of whether or not Rule 59 is applicable to motions to intervene. Can you address that?
Briefly, Your Honor, this court, this section of this court has ruled that it is. Just recently in the Carly A. case, authored by Judge McGee in January of this year, the court went into great detail on why Rule 59 applies to Rule 24 motions, and the court so found. Thank you, Your Honor.
Thank you.
Mr. Spence, we started the day with you. We're going to end the day with you.
Not sure if that's good or bad, but
Remains to
Robert,
be seen, doesn't it?
it's been an interesting day, but Robert Spence, on behalf of the appellee, member of the Shelby County Bar. The discussion that the panel has had with Mr. Shelton, I think, encapsulates the issue. The issue is whether or not they are a party to this proceeding and whether or not they have the right to file the appeal that they filed. As Judge Stafford mentioned, with regard to the December motion to intervene, an order was entered denying it. There is no issue in this case that they did not appeal that. There's no issue that when that order was issued, it was a final judgment pursuant to Rule 24.05. Now, after that order was entered, they filed a motion to amend, and they've argued it was really a Rule 59, and I don't believe that because as Rule 24 is worded, Rule 59 has any applicability to a Rule 24. Now, Mr. Shelton just mentioned the case. I haven't read it, but my ruling, but my reading of the rule and Rule 59 leads me to conclude that a denial of the motion to intervene is not subject to a Rule 59 because it is a final judgment as explicitly stated in the rule, and Rule 59 motions apply to matters where you're trying to not have a final judgment, but the actual rule says it's a final judgment. So,
Wouldn't the effect of it though is the same as you would have with a final judgment? In other words, it would extend the time for the what would otherwise be a final judgment to not be final until the court ruled on it.
if that is the way our Rule 24 is to be interpreted, but I don't believe that it is. I believe that because the rule itself, the rule says this is the final judgment, and 59 is meant to prevent a judgment from becoming final, that the rule in and of itself exempts it from Rule 59. That's my reading of the rule. But even with regard to,
Would that not make it different than any other rule contained in the rules of civil procedure then?
I'm sorry, Jeff, I didn't quite understand you.
Rule 24 doesn't say that it's to be interpreted any differently than the rest of the rules of civil procedure, correct?
Correct.
It just says essentially that this is a final judgment.
For purposes of trap 3.
Correct.
That's what it says. So I think when you read all those together, 59 has no applicability to a final judgment denying intervention because it's meant to prevent the entry of a final judgment. But even
And trap 4F also states that for purposes of this rule, the terms party and party shall include any person filing a motion to intervene pursuant to Rule 24.
that is correct. And what 4F does, 4F just makes it clear that appellate rights are available to the losing party who sought to intervene but were denied, because only a party can appeal. So Rule 4F is just establishing that if a non-party loses a motion to intervene for purposes of the rules of appellate procedure, they are a party with regard to the appeal that they have the right to file under Rule 24.05.
Do you have a case that a Tennessee case that says that Rule 59 is not applicable to a motion to intervene?
I do not, Judge. In my brief, I tell the court that. I tell the court that this is my reading on this relatively new rule. I have read federal cases that interpret FRCP 24 in the same manner that I'm explaining to this panel, but I could not locate a Tennessee case that dealt with this issue in the way that I am articulating.
I believe there's a Western Section Court of Appeals opinion that arises out of Memphis. I think the city of Memphis was a party in which someone was shot, perhaps someone was killed. I think it's a police case. And the panel struggled with whether when a denial of a motion to intervene, and this predates the rule change, if it in fact was a final judgment. And in an abundance of caution, the panel went ahead and said, if it's not a final judgment and there was no law on that, then it exercised Rule 2 and exercised good cause and went ahead and decided the case. I believe that is the progenitor of why there was a rule change.
Understand.
Now, I'm not absolutely positive, but I believe that's the sequence of events that got us to where Rule 24 was changed, where the final judgment language was added.
Okay. But even with regard to the motion that Regents filed 30 days later, a motion to amend, as this panel is well aware, if you're going to file a Rule 59, you've got to be pretty specific. The motion that Regents filed doesn't mention Rule 59. The motion that Regents filed does not mention any of the 3 or 4 criteria upon which Rule 59 relief can be given. I don't believe it was a Rule 59 motion. I believe it was a motion to reconsider. And I don't believe that in looking at the four corners of that motion, can it be interpreted as a Rule 59 motion, as a Rule 59 motion. And so I don't believe that that motion, because when you read it, even if I'm wrong about Rule 24, it could not toll the time for filing an appeal because it's not a Rule 59. It's just not a Rule 59. It doesn't even try to purport to be a Rule 59 motion. So Regions, we know at that point, is a non-party. Is a non-party. Regions then sets about filing pleadings in the case as a non-party.
Let me ask you about another
Yes.
interesting aspect of this that I'm curious about.
Yes.
Speaking of non-parties, your motion, the motion that you filed or your firm filed to receive attorney's fees was filed not in the name of your client, but in the name of your firm.
That's right.
You're non-party. Your firm's a non-party. How did the court, by what authority did the court award your firm as a non-party attorney's fees?
Your Honor, that wasn't addressed by the court. I know that with regard to two other law firms that were involved in the case, the court awarded them fees greater than the fees that were awarded to my law firm.
Awarded them fees pursuant to a motion by the firm directly as a non-party, or via their clients?
I don't recall, Judge.
I can't speak to what the court did to anybody else. I'm asking you because we do know in this case that your firm filed a motion in your firm's name, not in your client's name, but in your firm's name, and the court awarded your firm fees as a non-party.
And this hasn't been an issue, but there may have been in the record an accompanying affidavit from the client, but nobody has brought this up before, and so I don't know.
Well, your client was dissolved at that point in time, wasn't it?
I don't.
Administratively dissolved?
I do not know, Judge Golden. I don't know, but the record may very well contain an affidavit from my client in support of the fee bill, whether or not they were in compliance with the rules of the Secretary of State, and whether or not they were subject to administrative dissolution at that particular time. I just don't know, Judge. I just don't know.
Well, if the record reflects that they were, in fact, administratively dissolved at the time that this order was entered, by what authority first of all, could they have even filed an affidavit?
Sure they could.
Even if they were administratively dissolved?
Sure they.
I don't know whether one was filed or not. All I know is your firm filed a motion in its own name as a non-party seeking attorney's fees, and the court awarded your firm, a non-party in its own name, attorney's fees. And I've never seen that before. I was curious as to how that could be done, by what authority the court had to do anything like that.
Well, and as I've said, the record, I think, likely contains a submission from the party in support of the attorney fee application. But nobody's brought it up, and so I'm just doing it from memory. But I don't.
How could your client give the court authority to do that in your own name? The court could if in fact there's a basis to award attorney's fees, it seems like the court could award attorney's fees to the client. But I've never seen it done the way it was done in this case.
I understand, Your Honor. That's procedurally, that's the way it happened. And so,
Have those attorney's fees, as I understand it, those fees are derived from the sale of this property that Mr. Shelton was speaking of, I guess, that were paid into court? Are those fees still in the court?
No, those fees were dispersed to my firm and to the client in a subsequent order of the court. So then the procedural posture of the case, I think most relevant to a resolution of this issue, is that the court then entered a order of dismissal in July. There was no appeal. None of the parties to the case appealed. Nobody wanted to appeal. Regions, then the court enters 90 days later, I think cleaning up the record, a post-judgment order denying the motion to amend order on fees, and then Regions appeals that. And as we know, at best, that would have been an interlocutory ruling, and you can only appeal an interlocutory ruling under Trap 9 or 10, but they never appeal from the entry of the final judgment that was June 1, 2021. So
You're saying that there can't be, you cannot make an additional motion to intervene on a new issue?
I'm saying that one was not made. There is no motion to intervene filed pursuant to Rule 24 in this record other than the one that was filed in December of 2020 that was denied. There is no other motion to intervene. And the record is clear on that. There is no motion in this record styled as a motion to intervene except the one that was denied from December of 2020. Regions is not a party. Regions did not appeal the dismissal of this matter. It couldn't have. Regions could have gotten in, could have appealed.
Let me ask you a question.
Yes, Judge.
You say Regions is not a party,
Yes, sir.
and I agree that they were denied the right to intervene.
Right.
But if they were not a party, how could they present evidence and participate in the hearing?
I'm not sure that they did present evidence and participate. They filed motions. So,
Did the court consider those, or did it?
Your Honor, the orders from the court reflect that he gave them due consideration, and then he would say, but you're not a party, and I'm dismissive of it. Why are you filing pleadings? So the orders from the trial court reflect that, notwithstanding the fact that Regions was not a party, that he had specifically denied their request to intervene, that on one or two occasions when they filed something and he entered an order on it, he mentioned the fact that he had looked at it, he had reviewed it, he had considered it, and he had dismissed it. I don't believe that makes them a party. I think that just makes the chancellor trying to be complete in his rulings. He's just trying to be complete and thorough. But he doesn't make Regions a party, because we know how a non-party becomes a party, through an order of the court making them a party. And we know that in this case, that didn't happen. Thank you, guys.
Well, let me ask you this. After the December order denying intervention, Regions filed something that it titled Motion to Amend Order Denying Regions Bank's Motion to Intervene.
Yes, sir.
And then that was filed within 30 days of the December order. What was the date of the ruling on that motion to amend? What's your understanding of the date of that order?
And I think that the date, well, let me correct myself. I'm not sure that there's ever been an order entered on that.
Wasn't there an order entered on September the 9th of 21?
It was order denying motion to amend order on fees.
Order on fees.
Right, order on fees. That's what got Regions here. But the motion to amend order denying intervention, Regions never set it for hearing. It just was never ruled upon.
Where does that leave us?
Well, I'm not sure it leaves us in a bad place, because even if Regions intended it to be a Rule 59, if you read it, you know it's not a Rule 59. And because it's not a Rule 59, it didn't prevent the order denying intervention from becoming final, to which Regions never appealed.
And then Regent's motion regarding the attorney fees was just a motion to amend the order awarding attorney fees, but there was no prior motion other than the earlier motion to intervene. Is that right?
Correct.
Okay.
Thank you.
Thank you.
Enjoy my day with you.
May it please the court, I don't pretend that this case is a model of procedural precision. By the same token, let me put it simply. Regions had no reason to be unhappy with the disposition of what we call the first motion. However, Regions, by its motion to alter or amend, and specifically in what we call the second motion, requesting intervention to...
Well, tell me the date of that second motion, because all I'm seeing is a motion filed in January of 21, and you don't call it a motion to alter or amend, you just call it a motion to amend.
That's what we called it. We called it on January 21, Regions motion to amend order denying Regions motion. Then on March 12th, we filed...
That would be the first motion, correct?
Second. First motion was filed December 15, 2020. Was ruled upon December 22nd, 2020.
Did you file, is that the one that the motion to alter or amend was filed?
Yes, Your Honor.
Okay.
30 days later,
Okay.
29 days, something like that.
Okay. All
Within the time period, raising the issues again, and pursuant to that motion, we separately filed an objection to the Spence Law Firm's motion for attorney fees and expenses, raising, among other things, the issues the court raised on oral argument with Appellee just now.
I guess what I'm trying to figure out, did you file another motion to intervene because you wanted to be heard in connection with the attorney fee request? And if so, what is the date of that motion to intervene?
Your Honor, like Mr. Spence, I don't have it in front of me. I believe that the January 21st motion was couched in the alternative also to intervene. I can't swear to it. That's my recollection.
So it's a motion to amend and another motion to intervene.
That's the way that's what I would say, Your Honor, and that's, a 70-some-odd-year-old man's memory, so I'm not going to swear to it.
So did you then file a motion to amend pursuant to what I'm calling and what you've just described as the second motion to intervene that was consolidated with that January 21?
Yes, Your Honor, on May 18.
Okay, and what was the basis of the motion to amend on that?
That the court had erred in awarding the Spence Law Firm attorney's fees for a closing where the Spence Law Firm had nothing to do with the closing.
Is that the Rule 59?
They were both Rule 59s, Your Honor.
Well, you say they were both Rule 59. Do you even refer to Rule 59 in the actual motion?
I believe we did, Your Honor, but I don't know that the rules, as a matter of fact, I know the rules don't require us to reference Rule 59 as long as we set forth the standards of Rule 59, which we definitely did. Alter or amend for the reasons set forth in Rule 59. That's the way we argued it, and that's the way we briefed it below and here.
Okay. You always say motion to alter or amend, but I keep reading motion to amend. I don't see the alter or amend. Do you know, that you actually
Your Honor, I can't swear that we said alter or amend. I know we said amend, and I know we tracked the Rule 59 language.
Okay.
It's an active Rule 59 motion. And again, we had no reason to raise the point again until basically the court took our money and after the court set how the court was going to do it, the court was going to put the money in the registry, and we'd argue about it later in the old case. Then the Spence Law Firm filed a motion in what I call the new case, this case, 2017. And again, we had to find out about it and appeared and objected and said, this isn't what the court ordered. Can't do it this way. The court promised that, we'd hear it in the 2014 case.
Let me digress from where you're going for just a moment. Your second motion to alter or amend, the fee request.
Yes, sir.
What's different in the motion to alter or amend than was presented in your objection?
They would be pretty much the same, Your Honor.
So why is that not a motion to reconsider?
It's not a motion to reconsider for the simple reason that the facts changed.
I understand that.
And we were.
You're talking about intervention generally. Here you're talking about a specific attorney fee.
We're talking about two different reasons to intervene. And frankly, it would have been cleaner if we'd called it a second motion to intervene, but we didn't. But what we did do was raise and preserve the issues, have the court rule on them on the merits after due consideration, and issue an order which we submit was erroneous.
Okay, let me try to clarify this in my mind anyway. Your second motion to intervene was essentially an objection to payment of attorney's fees, right?
Yes, Your Honor.
Was there a second motion to intervene filed?
I would have to look at the language of the January 21
So you're treating
motion
the
to
January 21 motion also as a renewed motion to alter or amend?
Yes, sir. On the grounds, again, the situation changed in that month.
I understand that, but now we're dealing with a January 21 motion to alter or amend, and then you're dealing with your next motion to alter or amend, right?
Yes, Your Honor. There
What's
were two
different?
motions to alter or
Yeah.
amend.
What's different between your first motion to alter or amend and your second motion to alter or amend?
Had the fees been awarded when this January 21
No, Your Honor.
motion,
No.
that was prior to the awarding of fees?
That was, we filed that immediately upon learning that Mr. Spence and his law firm had filed the new application.
So this is the second motion to intervene?
Yes,
So to
yes, Your
intervene
Honor.
prior to the time that the fees were awarded?
The motion to intervene originally was filed in December of 2020 in order to get the relief that we got.
And then this January 21 order seeks to allow you to intervene prior to the court awarding
Yes, Your
Mr.
Honor.
Spence any fees?
Yes, Your Honor.
And then
And
that was followed after the court ruled on that. Is that right?
actually, Your Honor, what happened was the court gave the parties a chance to brief the issue. The parties briefed it. It was set for hearing in April of 21. At that point, the chancellor took the bench, said, I don't need oral argument, here's what I'm going to do.
That was the order of September 9, 2021.
No, sorry.
Is that
sorry.
when the court ordered?
The court ordered the award of the fees orally in April of 2021, and then entered the order, I forget what the date was, April 19. April 12th is when the court ruled without oral argument. April 19 is when the order went in, and then there was a subsequent motion to amend order filed within 30 days. That one on May 18. That's the one that was ruled on September 1. So and I'm way over my time, let me just sum up if I can by saying we did everything we could to get the issue before the court. We think the court gave us consideration but made an erroneous ruling. Thank you, Your Honor.
And your last argument, is that part of your argument to suggest whether there's an order granting you intervention because of the nature of the trial court's ruling, you are a party such that you can appeal?
Yes, Your Honor. I mean, if he had said, shut up, sit down, go away, I think our only choice would have been to appeal, but he didn't. He let us argue, he let us brief, he would have let us put on proof if we'd wanted. He treated us with a great deal of courtesy and respect. I've got no problem with that, I just got a problem with his ruling. And I also have a problem with the fact that he called it denying intervention when, as a matter of practical fact, he didn't. It's very much like the Lamar case that we cited.
And in the order, he actually said that he considered your objection.
Yes, Your Honor, he did. He heard us out. He asked questions.
All right. We will take this matter under advisement and attempt to render an opinion at the earliest possible time. Ms.
Thank
Angie will be in recess to the call of the docket.
Thank you, Your Honor.
All rise. This court stands adjourned.
But now we don't have